We've got a quorum already. So may I now call to order the fifth meeting of the Bills Committee on Insurance Companies Amendment Bill 2014. Please invite the administration in.
On the
21st of July 2014, the Bills Committee didn't have a chance to discuss the paper on the summary of public comments on the bill and the administration's response, enhanced existing regulatory powers in respect of insurers, and new regulatory powers in respect of insurers. This is in fact paper 1817/03. So can the administration now take us through the paper and then members can ask questions? Yes, thank you, Chairman. This paper summarizes comments made by the public on the bill and the administration's response. In fact, we took members through our responses at previous meetings. And then concerning the regulation of intermediaries, I understand that we're going to have a discussion later today. And so to save time, I will not be taking members through the paper. But then, of course, we welcome members' questions and we'll try our best to answer them. All right, Mr. Yu Si-wing? Thank you. Chairman, concerning regulatory bodies, and I'm referring to the SFC, there is an appeal mechanism. And I can't remember the name of the appeal body. You mean for the IIA, there is a tribunal. And so I want to ask whether you would like to have a similar mechanism for the IIA. I mean, a mechanism similar to the SFC mechanism. I remember at one meeting you said that there could be a board or a committee to oversee and supervise the operation of the insurance authority. Is that correct? Chairman, thank you. At the moment, the arrangements for the insurance authority and the SFC are the same. I mean, after the SFC has made a decision, the decision can be reviewed by the tribunal, and if the party concerned still feels aggrieved, then the matter can go to the Court of Appeal. And in fact, for the OCI, we do have a review committee, or for example, a review panel to look at the process, whether there has been delay, and so in fact the arrangements are the same. So the review panel reviews decisions made by the OCI. No. Now say if there is an insurance intermediary who feels aggrieved by a disciplinary decision made by the IIA, then this intermediary can go to the insurance go to the tribunal. But then the review panel looks at whether the IIA has acted in accordance with its own guidelines. So the review panel doesn't look at individual decisions made by the IIA. The review panel looks at whether the authority has been acting in accordance with guidelines. So is this a regulatory body? The IIA is a regulatory body, but then of course there will have to be checks and balances. We have to make sure that the IIA exercises its powers in accordance with the law and the relevant regulations. And so there is the review panel. And can I know more about the powers of the review panel and its composition, please? Thank you. Concerning the review panel, Chairman, I want to say that there are similar organizations for the SFC, for the Financial Reporting Council, and the MPFA. These review panels comprise members of the public and also members from the industry. Now, for the MPFA, Mr. Fong Cheng, a retired accountant, is the chairman of the review panel. And then the panel also comprises representatives from the industry. And so for the review panel, of course, there will be representatives from the insurance industry. There will also be accountants, lawyers. They will make sure that the IIA acts in accordance with the powers laid down in the law. So the review panel cannot only make recommendations. Is that right? Can the review panel exercise any checks and balances on the work of the IIA? Yes, Chairman. Yes, basically that's true. The review panel makes sure that the IIA acts in accordance with the law and the regulations, and it can make recommendations. Now for the MPFA review panel, it's a new panel, and so it has yet to publish its report. I want to say that the IIA has to take follow-up action in response to recommendations made by the review panel. I hope that the powers of the review panel can be clearly spelled out, and I hope that there can be more representatives from the insurance industry sitting on the review panel, because the IIA is going to enjoy very big powers, and so I think adequate checks and balances are required. Thank you. Right, any further response? Thank you, Chairman. We will note members' views. Any further questions from members? No, then I think we can move on to the next paper.
Now, according to the views of the committee we earlier expressed, now next we will talk about the licensing regime for insurance intermediaries. The document is CB-1 2027/13-14/01. Perhaps the administration can take us through it first before members ask questions. Now, today we are going to mainly talk about the regulation of the intermediaries. There are two related documents. The first is about the licensing regime, and the second is about the regulation and disciplinary actions. Now, they are closely related, so if the chairman does not object, after I talk about the licensing regime document, I will talk about the regulation and disciplinary actions. Yes, that was what I was going to move to. Now, since the Secretary says that the two are closely related, you can talk about both. So it's the two documents, CR bracket 1, 2027, 1314, bracket 01 and 02. Now, under ICO, in Part X, that is Part 10, there is already description of the regulation regime. But right now, it's a self-regulatory regime. There are three self-regulatory organizations. These are the Insurance Intermediaries Registration Board, the CIB and the PIBA. Now, so we will change from this self-regulatory regime, and the three self-regulatory organizations, those who are registered thereunder, once the new regime is set up, they will be treated as licensees within the next 3 years, a transition period, so they don't have to get a new license. Now, there are 4 parts in the provisions about the licensing regime. The first is the definition of regulated activities, that is, anyone who engages in regulated activity will have to be licensed from the IA. Now, what's regulated activity is in paragraph 6. It's arranging a contract of license, inviting or inducing a person to enter into a contract of insurance, etc. And in para 10, we said that if a person is not licensed, he cannot use the term insurance. So if I am not a licensee and if I print on my name card an insurance agent, then that's against the law. And if one promotes insurance activity in the Hong Kong market actively, that is considered a regulated activity. And in para 8, we said that professionals, for instance, barristers, accountants, and actuaries, they are merely, when they are merely offering regulated advice incidental to their practice, they don't have to be licensed. And then there are trust companies, loss adjusters, and because very often family trusts hold insurance contracts, so these professionals, when they provide service and opinions, they are not the target of our regulation, so they don't have to be licensed. And thirdly, those who handle the administrative work, they are also not regulated. Now, there are 5 classes of licensees. Now, the categories are identical to the present, and that's in para 9. Mainly, there are 2 classes of intermediaries. The first are the agents, that is, they represent the insurance companies who sell insurance. And then secondly, we have the insurance brokers. They act on behalf of clients to identify the most suitable insurance contracts in the market. And we have individuals and companies. For instance, the licensed insurance agents, they might be cars vendors, and then there are insurance companies. They appoint some sales staff then that's a licensed individual insurance agent. And on the licensed insurance brokers, there are also two categories: licensed insurance broker companies. Now all the licensees are in fact companies, and the persons they hire are the licensed brokers. Now in the 3-year transition period, they will be considered as licensees automatically. Now after 3 years, one has to apply for extension and renewal of license. This follows the existing qualifications and requirements. The valid extension period is 3 years. When one applies for license and for renewal, if one submits misleading or false information, they can be fined and sentenced for up to 6 months. And in para 13, if a licensee, there's a license arrangement for a licensee not being able to engage. For instance, an insurance company hires some licensee, and the licensee may move to another company, so there's a period in between when he is not appointed by any insurance company. Now this is very common, so we must offer a transitory period during which he is not hired by a company, but he doesn't lose his license, because that would be duplicate a lot of work. So there's a 180 days grace period. If you find another employer within 180 days, you do not have to get a new license. Of course, after 180 days, if you are still unable to find an insurance company to appoint you, then the license would be terminated, and you then have to get a new license when you want to engage in the activity. And then there is a requirement for a responsible person. That is, in an intermediary, this person is responsible for internal controls and procedures, so that those engaged in intermediary activity in that organization meets our conduct requirements. For instance, because our regulatory philosophy is not to set certain rules and then try to catch the rule breakers. We ask that the agents and the licensees know what the requirements are, and they will then abide by those requirements. We are not trying to engage in active policing, catch and mouse game. Now, para 15 is about this RO statutory requirement for an insurance agent company or insurance broker company. If they do not have a recognized RO, their license would be suspended. Para 17 asks that the IA must hold a register of licensed insurance intermediaries so that the public can check which intermediaries are licensed. So the validity of the register depends on the licensees submitting the information to us in time. Now, if they do not inform us of the changes within a stipulated period, is an offense. Now, in para 18 to para 20, the existing ICO already stipulates that you have to be either an agent or a broker, and a person or company cannot be both at the same time. The reason is that the insurance agent represents the company, and whereas the insurance broker represents the customer. If a company is both an agent and a broker, then there's a conflict of roles. So this is not allowed right now, and similarly, under the new bill, we have updated the provisions to maintain the same control. From para 21 onwards, it's about the powers for investigation and inspection. Now, normally, the IA will conduct inspections on licensees to see whether there are internal guidelines set by the RO so that the intermediaries can abide by these controls and comply with the requirements. And when a complaint is received and there is suspicion there is a breach, then one can conduct investigation. And during investigation, the powers are about the same as those for the SFC or the MPFA. So the person being investigated has to be cooperative. He has to provide information. If he declares he doesn't have the information, he might have to supply a statutory declaration. And if there is the evidence that he destroys evidence, then there would be criminal implications. And in para 25, we say that if under some circumstances, if the inspectors demands a compliance and the person doesn't comply, and eventually it can be treated as for contempt of court. And para 29, now we talk about the situation in banks. Now, so the CE in council can confer the powers of investigation and inspection onto the monetary authority, so that there wouldn't be any duplication of work. And then there are other amendments from para 31. Right now there are provisions saying that the treatment of client funds have to be very careful on the part of the insurance brokers. Sometimes the brokers takes the money to pay the premiums and so on. And such funds have to be segregated from the company's own funds. And also it's been mentioned that there is a self-regulatory regime. Now the ICO provisions say that if there are complaints to be sent to the insurance company, the insurance company has to investigate. Now, if the company doesn't investigate the complaint, then that is a criminal offense, because right now the responsibility for investigation lies with the insurance company. But in future, the IA will be responsible for licensing and investigation, so the insurance company will no longer have the statutory responsibility for investigation, and the provisions will be deleted. So, because that would be more reasonable. So those are the main provisions regarding licensing. I can answer questions before we move to the next document on regulation and disciplinary action. Mr. Sin Chung Kai, and then Leung Sing. Chairman, I have a few questions. Now, on regulated activity, you have an Annex A, and it's quite detailed. So, now it includes the act of giving regulated advice. Now, sometimes people are just having a meal together and they might say, oh, you haven't purchased insurance. Now, some people just give an advice or opinion in a very casual manner. I don't think that's what you are targeting, right?
Thank you, Chairman. Now concerning the carrying on of a regulated activity, the bill talks about a remunerated activity. In other words, if one gives some advice on a regulatory activity but doesn't get any remuneration, then he will not be caught by the bill. But what is meant by remuneration? A cup of coffee, a meal. Are these remuneration? Now, of course, we have to look at the circumstances of individual cases. But normally, we're talking about people employed to provide the advice on a regulated activity. What about a self-employed person? Now, under the law, an insurance agent is a self-employed person because his relationship with the insurance company is that the insurance company is the principal. So for an insurance agent, he is in fact a self-employed person. Now, say for example, an insurance company hires a person to give talks on regulated activities, but in fact this person doesn't act as an agent. Then what is your comment? Now, say on TV or in the newspapers, we see programs or columns advising people that they should take out certain types of insurance. If these people are not insurance agents, if they will not, if what they do will not induce the entering into of a contract of insurance, then these cases are not caught by the law. All right, 5 minutes per member. Okay. Mr. Ng Leung Sing first. I want to ask a question about Para 9, Chairman. It is said that the IIA may review the categorization of licenses after the 3-year transitional period in the light of market developments. I want to know whether the IIA will look at the number as well. For example, if the market is prosperous, then will you set a cap on the number of agents or brokers? So I want to know whether you will consider relaxing your regulations. Yes, Chairman. Thank you. So within the first 3 years after the establishment of the IIA, things will remain unchanged. Licensees can continue with their activities, but then we can't now decide what's going to happen beyond the 3-year period. And if the IIA sees developments in the market which may affect the licensing regime, then the IIA may think that there is a need to make changes. But if the IIA really contemplates changes, it will carry out consultation as usual. And then concerning whether we're going to cap the number of agents or brokers. Now, I want to say that in Hong Kong, we've always had a very free market. And I think so long as companies or individuals can satisfy certain thresholds and criteria, they should be allowed to be licensed. And so at this juncture, I can't see any reason for having to cap the number of agents or brokers. If the IIA thinks that changes to the licensing regime are required, then the IIA will put forward proposals and carry out public consultation exercises. In fact, in the public consultation exercise, some said that the number of categories should be simplified. At the moment, there are 5 categories. We are open-minded on this one. But during the transitional period, we hope that for those who are now licensed, they will be deemed to be licensed in the future. And if we are to change the number of categories, then there may be confusion during the transitional period. But then, as Ms. Choi has pointed out, if the IIA feels that the number of categories should be reduced, then it can put forward its proposals. Yes, Chairman, thank you. I want to now turn to para 14. It is said that the copy of records will have to be transferred, and so on and so forth. But I just want to know whether these records can really be transferred to the client very smoothly. I'm worried that the client may not be able to get all the records, or may not be able to get correct records. Yes, Chairman, thank you. For insurance policies, the insurance contract is the most important document, and of course the insurance company has a copy. And so for the insurance intermediaries, they may make claims on behalf of the clients. And the intermediaries have to transfer such records to the client. This is to protect the interests of the policyholder. But I think it's Mr. Ng, I think you can follow up in the next round. Mr. Wong Yok Man. Thank you, Chairman. Concerning this paper on the licensing regime for insurance intermediaries, I've got a few simple questions. First of all, para 10. New sections 64U to 64ZD provide that an eligible person can apply for a license in a manner specified by the IIA and on payment of a prescribed fee. I want to know whether the prescribed fee has been changed in the bill. In fact, this is the fee for applying for a license, and I think the present level of fees is $300 to $400. Let me supplement. At the moment, now because there are 3 self-regulatory organizations, there are 3 sets of fee levels. In future, the IA will have to standardize the fee levels. And then in the same paragraph, it is said that a person can only hold or apply for one type of license, and the license is valid for 3 years. I want to know why the license can only be valid for 3 years. Chairman, in fact, this is in line with the existing practice in industry, because for brokers, insurance brokers, they have to renew their licenses once every 3 years. We do not want to have a new system which is too different from the existing administrative system. And then because of time constraint, I've got 2 questions. Para 14. New section 64 is that S provides that a revocation or suspension of license of a person does not avoid or affect an agreement, transaction, or arrangement entered into or arranged by the person. But then what if a person's license is revoked or suspended because of his conduct? Will his client be affected? And then para 23. It is said that new section 64 ZZH provides that the IIA may direct its employees or with the consent of the FS appoint other persons to initiate the investigation when the IIA has reasonable cause to believe, blah, blah, blah. So there are 4 scenarios. And I want to talk about C. And there are 54 characters in the Chinese version. If the IIA has reasonable cause to believe that a person has carried on or is carrying on regulated activity in a manner that is not in the interest of policyholders or potential policyholders or the public interest. Now, I think it's difficult to pause at the right time, at the right juncture. But anyway, I think this is really a very lengthy sentence. Last time we discussed 89 small a. Last time we had a discussion on the interests, the best interests of people. Now, it's abstract to talk about the interests of certain people. Who is to interpret what is meant by public interest or what is in the interest of policyholders? IIA? I am worried that 23C may give rise to some controversy. Yes, Chairman. Concerning para 14. The member is right. If the person has breached the law, then of course his license is revoked or suspended. But then for brokers, they need to continue to serve the clients. In other words, even if the license is revoked, he still has to discharge his duties towards the clients. And then para 23. Yes, I understand that sometimes some legal provisions may be lengthy and the syntax may be complicated. Now, concerning the licensee, he used to be a licensee, but then he is no longer the licensee. But then concerning what he did when he was a licensee, it doesn't mean that no investigation can be carried out.
And what's the implication of policyholder and potential policyholder? For instance, I want to get a client and I make a false representation, and then the person didn't purchase insurance, so he is not a policyholder. But that can already be the cause of a complaint and investigation. So that's where we have a potential policyholder. And I understand the member's concern. Well, we talk about the interests of a policyholder or potential policyholder or interests of the public, then how do you define that? Now, there has to be some subjective judgment. There has to be reasonable grounds. Now, the court takes that as a judgment by a normal person, taking into account the circumstances. So, if one feels that there has a breach of such interest on a reasonable basis, there is prima facie evidence of deception, then of course one has to investigate. That's the objective. Next, Wei Kang. I would like to ask about para 17 because it mentions 64O, 64P, 64R, and 64T. And the document says that when there is license to be renewed, for instance, business ceases, then one has to provide notice within a certain period. Now, 64 hours, etc., 64T, we understand 14 days notice is reasonable, but as for 64P, for insurance intermediaries, we feel that this is too harsh because even if one changes the phone number or the fax number or some other simple information, then one has to serve notice within 14 days. Now, it's difficult because the intermediaries have to deal with a lot of other things in their day-to-day business. So can you be more lenient in this regard so that people are not kept on the edge of their nerves? And can you also answer the question, what form of notice is accepted? There are likely to be some forms, for instance, email, fax, or by post, or personal submission. Can fax or email serve the purpose? Now, I can't answer on behalf of the IA, but I expect it would be okay, and there should be forms for updating of information. This is not a requirement. There is already such a requirement in the self-regulatory regime. Now, as I recall, this seems to be 7 days right now, and we are making it longer. And we have discussed this with the trade. If the trade feels that 14 days is still too stringent, we can talk again. Now, we are talking about simple information. There should be ample time for updating. It's because the data is too simple. Now, because one can infringe the law so easily. Now, you say the information is very simple. Of course, if one stops being a member of the trade, then of course one has to tell you. Now, the administration promises to listen to members' views. Now, initial suggestion, I believe, was 7 days, and after talking to the trade, it was extended to 14 days. Now, Mr. Kwok, you can insist if you like. Second round. Chen Kim Po. I have too many questions, so I want to wait till the others have finished. Sin Jung Kai. Well, one can only have 5 minutes, and one can queue again. So 5 minutes, Mr. Chen Kim Po. I'm talking about 2027 1314 bracket 01. Now, on page 2, it talks about regulated activity, and there's an Annex A, what the government considers to be regulated activities. And here, there are more comments by the trade. Now, what used to be called referrals. It can be in two forms. One is a verbal referral. One client refers the intermediary to another. It doesn't involve regulated activity. The product, etc., is not mentioned. They immediately say this company is a good one. You can patronize it. So it's called member get member, and the company may give them some reward, like a gift coupon. Is that allowed? And secondly, both sides are licensed. Now, there's a licensed intermediary who is not very familiar, and whereas the other intermediary is more professional and he refers the business to them, and of course he gets a reward. So what would the government do in these circumstances? The government is concerned that if both persons are licensed, then one doesn't know who is to be held responsible. So it's good to set the principle in black and white, but you must understand that there are practical difficulties. So these are more in-depth discussion. We hope you can understand that the trade is supportive, but these are issues that need to be resolved in a frank manner. People need to be able to conduct their business. We hope to have a win-win situation. Now, so I will let you answer first. Secretary? Now, where we know there are business referrals, that may not be what we are trying to regulate. The regulated intermediary activity is in a case where the intermediary must have some professional knowledge and he must honestly engage in the regulated activity. We know that there are referral activities in the trade. I repeat, this is not what we are trying to regulate. That is, referral is not a regulated activity. That is, even when there is reward. Yes, the Secretary has just spoken. Now, we also have to prevent some loopholes being exploited. So, so the IA has to set out what are the situations under which there can be referrals. So one can speak very clearly, and the person who finally arranges the contract has to explain clearly, and he has to be a licensed person. So that kind of referral activity is not a big problem with us, but one has to be very clear on who does what. So right now, for the self-regulatory organizations, they also have these guidelines that if you do this, then this is allowed or that is not allowed. And in the future, this mode will also be followed. That is, under such circumstances like member get member, or I'm not a professional in this type of contract or policy, then I refer to another. That's not a problem, but one has to be clear on who will be responsible, what are the limitations or restrictions on the referring person, and what does the other person have to do. So when are you going to let us know what will be the referral procedures that you have in mind? Now, on the issue of the code, that will be done by the future IIA, and they will draft a code for intermediaries. They will then consult with the intermediaries before they publish the code. So that will be the work of the IA before it can implement these provisions. So the trade would have ample opportunity to see what the restrictions are and whether their business will be affected. Just now, for instance, Mr. Chen Kim-paul's views, of course, the future IA will draw up the code, but will you have a memorandum to be submitted to the future IA covering what members have raised in these meetings, so that the IA will pay heed to these matters in drawing up the code? We can draw up such a memorandum, and we have had reference to the regulatory systems in other jurisdictions. In some cases, they don't regulate such referrals, and they do issue guidelines, as the Commissioner said, and we can let you see what these guidelines are, and this will be a record that the future IA can refer to. Sin Chung Kai? Now, even there is no regulation, it must be made clear that disclosure is necessary. Okay, I make the disclosure, I get a nominal reward. That has to be made clear. I'm talking about, I'm going to talk about para 17. The one cannot be both an agent and a broker. That I agree with, but sometimes there might be a situation where a holding company set up two companies. One acts on behalf of client and one acts on behalf of the company. So they have the same parent. So what do you do in regulating that situation? That's correct. We do not allow the same company to act in both roles. That would be too obvious a conflict. Now, if it's a group with these subsidiary companies, this is allowed under the ICO because there is a corporate veil. The two companies have different clients and businesses, but if Company A acts as an agent, you are a director and you're a director of the other company also, then you can't participate in the business of the second company, because otherwise there would be a conflict of role. Now, if the parent company has a shareholding on both sides, that is not a problem. Each has its directors and responsible officers who must follow the code of practice. So the two companies will be separate, but in decision making, the same director cannot take part in both companies. Now, para 29, the HKMA will be delegated the powers. Now, delegation is okay, but how about bank staff? Do they have to be licensed? Yes. It's also a 3-year license? Yes. Now, I'd like to ask. Now, maybe I haven't read very closely. Now, insurance involves many levels, and life insurance has its own arrangements and so on. Household insurance, travel insurance, etc. And when one sits for the licensing examination, are there different examinations for different issues? or areas. Now, there are several papers: general insurance knowledge, life, non-life, investment, etc. So it depends on which papers he has set before he can engage in the activity of that paper.
Now, say for travel agents or travel agencies, say if I go to Guilin for a 4-day tour, then the travel agency staff may ask me whether I want to take out travel insurance. So do these staff members have to take the exams? I understand that in 2004-2005, a special arrangement was worked out for these people. So there are restricted licenses for travel agency staff, and these staff can only sell travel insurance policies to the customers. So their area of business is restricted to travel insurance. And this arrangement will continue. Yes. And so in other words, after the 3-year transitional period, the staff will have to sit these exams again. Not necessarily, but at least they can go on with their work during the 3-year transitional period. And during the transition period, the IIA will have to review the information concerning companies and also licensed persons, and we think 3 years would be enough for the IIA to do the administrative work. And maybe after the 3-year period, these people will be able to renew their licenses without having to sit the exams again. Mr. Ng Leung Sing, I want to go back to a previous question. And that relates to para 14. Now, if a person's license has been revoked or suspended, of course, something bad has been committed by this person. And so concerning records transferred to the clients, these records may not be complete. And what if clients have difficulties making claims because of incomplete records or inaccurate records? What is the role of the IIA? The client may encounter difficulties because the licensee license has already been revoked or suspended. And so can the IIA act as a gatekeeper so as to better protect the interests of the policyholders? Chairman, thank you. I thank Mr. Ng for his question. Now, if a licensed organization has its license revoked or suspended, and of course the regulatory body needs to protect the interests of the clients. Now, the broker may be holding the policyholders' money, or the broker may be holding certain assets or certain documents belonging to the client. And so we must have the statutory power for the regulatory body to direct the company or the business entity to transfer the records back to the clients. And if the client suffers losses as a result, then I think he should make civil claims. But then if a a license is revoked, then of course, as obvious as something very serious has happened. And I don't think you should expect the client to come to LegCo to complain and seek assistance. Because if a license is revoked, then something very serious must have occurred. So can the IIA try to give more protection to the clients or the policyholders? I'm not saying that you have to include such protection in the bill as soon as right now, but then I think you should consider ways to give more protection to the policyholders. I want to say that the group that I'm working for does offer asset wealth management products. Para 29 says that the IIA may, subject to the approval of the CE and Council, delegate its powers of inspection and investigation to the monetary authority. It's really not desirable to have duplication of work between two regulatory bodies. So the IIA will still be responsible for issuing licenses. And how are you going to coordinate your work with the work of the MA? Now, of course, the IIA will be taking the lead. Mr. Yu Si-wing, I need to declare interest. I operate a travel agency, and the travel agency also offers insurance service. I want to say that I welcome the 3-year transitional period. The 3-year period will be for us to adjust to the changes. Now, in fact, our colleagues are not primarily responsible for insurance business. I want to know whether during the 3-year transitional period there will be there will be more relaxed arrangements, because I'm worried that if our colleagues inadvertently breach the law, then they may immediately become criminally liable. And then para 23 or para 21 to 22, it says that the inspector can have very great powers. The inspector may enter the premises, inspect and make copies of the intermediaries' business records and make inquiries. I want to know whether the inspector is going to be an employee of the IIA, or will the IIA appoint another company or intermediary to be the inspector? I think if the IIA is to appoint an intermediary to be the inspector, then you'd better be very careful, because the intermediary may not fully understand the IIA's powers. Now, say for example, my travel agent only offers insurance service for the convenience of the customers, and if the inspector comes and inspect the travel agency and carries out an extensive search of all records, then that may not be very desirable. So the requirements in the future will be basically the same as those at the moment. For example, the nameplate requirement, and other requirements, I don't think there will be major changes. So it doesn't mean that we need to be relaxed. But then if the IIA wants to make changes, as I've said just now, it will have to carry out a public consultation exercise. And so I don't think that there will be very big adjustment problems. And then appointing the inspector. Now say when we appoint an auditor to carry out certain inspection or investigation work, the entrustment document states very clearly that he can exercise certain powers under certain sections of the ordinance only. In other words, the auditor, for example, can't get hold of or inspect any document or any record that he likes. He will only be empowered to look at relevant documents. So the legal basis for his work will also be spelled out in the entrustment document. Now, of course, auditors have to comply with their professional code of conduct. I understand that in the tourism sector, sometimes inspections are carried out, and sometimes security companies are appointed to carry out the inspection. And of course, for auditors, we have confidence because they need to observe their professional codes of conduct. When we appoint an inspector to carry out inspections, of course, we'll spell out very clearly what his powers are. And concerning undercover operations or mystery shopping programs, yes, there are these programs to look at whether intermediaries do observe the codes and the guidelines. But when we appoint intermediaries to carry out these mystery shopping exercises, we clearly delineate the powers of the intermediaries. Mr. Kwok Wai Keung. Thank you, Chairman. Back to 64 R, T, and S, and also 64P. Date. The Deputy Secretary said that he would listen to the views of the industry. That's good. And how come you've decided that it will be a level 5 fine? Now, because we're talking about very simple information only. Level 5 means about $50,000. How come people have to pay such fines when they inform you of a change in the telephone number late? And what do you mean by a reasonable defense, please?
Why is there a sanction? Because there's some information that only the licensee has, so he has to meet the obligation. Now, on the penalty, we've talked to the Department of Justice, and this is similar in gravity to to offenses of similar gravity elsewhere. Now, For instance, the agent went on a tour, he was unable to submit the form in time. That would be a reasonable defense. Now, all closely related is the regulation and disciplinary action document. Can we go on to that? Let's complete this question first. Now, the administration feels that $50,000 is a suitable level of fine. Is a maximum fine? Yes. And the fine has to be levied by the court? No. Now, even if there's an infringement, it doesn't mean that the fine is automatic. It depends on the circumstances. One has to be reasonable. Now, if it's a momentary negligence, it doesn't necessarily mean that the regulatory body will immediately issue a debit note. Now, the law gives the IA the power in respect of some simple offenses to prosecute and lay charge. So that is a power to issue such a demand note. So one has to wait for the IA to set the fine. The amount of fine is already stipulated in the law. The maximum is $50,000, but one can levy a lower fine. Now, what I mean is the fine is not automatic. Now, if there's a reasonable defense, the person is abroad or is momentary negligence, it doesn't mean that the fine is automatic. I'm at a loss. Now, you have stipulated a maximum, but you are saying that the fine is not bound to happen. Mr. Kwok, I think I am able to understand, but it's just a general knowledge issue. Now, all the stipulated fines are the maximum fines. When the court awards a fine, it may not be at the maximum. And also, there's reasonable defense concept. Now, many provisions in law have such a provision. Now, this is common knowledge in common law. Now, the courts have a good grasp of that, but I agree that you should confirm this with the administration. Chairman, we have to look at the intent. For there to be a fine in a criminal offense, there has to be intent. If the person has the intent to fail to submit some updated information to the IA, then normally there would have to be a fine. But if, as I said, it's just due to momentary negligence, then the fine may not be levied. Next, Chen Kim-po. Now, I thank you about the memorandum. Of course, I trust you both, but some of the members of the trade are worried that you might not actually do it once the bill is passed. So I hope you can put everything in black and white, and I hope this also applies to the future, that people can have a high level of trust. Maybe you can put it in the form of a memorandum or some other form, so the rules for referrals, etc. My second question is in para 7, you said someone actively promoting insurance activity from outside Hong Kong, that would be treated as a regulated activity. Now, you say actively marketing a product. Do you leave the interpretation to the court, or do you have certain guidelines? Now, actively, that means not just verbal, but actual selling of insurance contracts. Of course, it's difficult for me to be definite right now because it all depends on the circumstances of the case. So we have to include this, but I can only tell you that one is actively promoting or marketing the insurance product. Now, where possible, we will cover this in the guidelines or code of conduct on what will be considered a regulated activity. Now, the code by the IA will make it clear. But in the bill, we must include this principle. Now, there can be two scenarios. Firstly, the depth of the talk and how many occasions. Now, if you talk actually about the product, now, some people saying actively, it's not just once. Well, it doesn't depend on the number or the number of occasions or how frequent it is. It's not on the basis of number of occasions. Now, para 8, it says that you can exempt the professionals like solicitors and accountants. But how about a loss adjuster? That's not regulated. Anyone can set up a loss adjuster company. Now, the loopholes should be plugged by the government because loss adjusters are involved in illegal activities. So are you creating a loophole here? Now, internationally, there is no standard on whether loss adjusters should be regulated or how they should be regulated. Now, some jurisdictions that are close to those in Hong Kong do not regulate loss adjusters. Now, either the claimants or the insurance companies can seek the service of loss adjusters, so they are not just one-sided. Now, they are familiar with the loss claim procedures, and they offer the advice and engage in the work. So we do not have a plan to regulate them. Now, there are not many people in this line of business in Hong Kong. To our knowledge, there are about 30 or 40 loss adjusters in Hong Kong, about 300 to 400 people. I think we should take and how things develop, see how the market develops. Now, in past insurance deception cases, we haven't seen any large-scale involvement by loss adjusters, and no loss adjuster was convicted. Now, it doesn't mean that we won't take a second look in the future. We monitor the development of the market, but we do not intend or plan to do this right now because we try to follow the existing practice so that the transition would be easier. Simple question. When a loss is claimed, one doesn't necessarily have to go through a loss adjuster. Yes, it depends on the individual. Third round, Sin Chung Kai. Now on para 17, information for the public inspection. Is it that it can all be done online? Now, also, para 28, a warrant has to be secured for entering the premises, but how about para 22? Now, if they refuse, then you have to get a warrant. Is that right? And then para 25 it says about the licensees. The organizational licensee. Now, you list the matters that have to be considered. Is there an objective standard? For instance, personal reputation and integrity. Do you have objective standards? What circumstances under which you will refuse? Do you have to give your grounds when you refuse? Now, on the last question first, when we reject, do we give reason? Now, well, whether they are fit and proper person. Now we do this right now. We see whether they have been sanctioned in other professional organizations or in other jurisdictions. If they are coming from abroad, then we see whether they have been the subject of matters like criminal offenses or bankruptcies. So we look at these objective criteria to see whether he's a fit and proper person. So if somebody has a criminal record, then you don't let them register. We do have objective standards. We will stipulate in our code who is a fit and proper person, and in the application forms we will ask whether they have been subject to sanction in other jurisdictions. So we will have the information for our basis. Now, as for criminal record, it depends on what criminal offense. If it's just a traffic offense, then it may not directly impact our decision. But if there are offenses related to integrity or conduct, then we will consider that. Para 17, online information. Yes, one should be able to get the information online. The entire record or the entire record. Detailed information on each intermediary, when license was first issued, whom the person represented in the past. Does that include past sanctions? Now, in general, we try to make public the information on past sanctions. Yes, that will be included. So if the sanction was a public one, then it would also be mentioned in the record. How about entry into premises? Two different criteria, it seems, in the two different provisions. In one, a warrant has to be obtained. In the other, it's not stipulated. Now, where warrant is required, it's what's called domestic premises. If it's not domestic premises, then the requirement is less stringent? Yes. You can check with your colleagues. That's correct. If it's commercial premises, no warrant is necessary. Next, Chen Paul. It's difficult. I would rather prefer being given 20 minutes and ask in one go. Now, the term loss adjuster doesn't appear in law. No, it says that if the licensee is involved in claims work, then that would be more appropriate. Now, why do have loss adjuster? Because if one doesn't have a loss adjuster, then one may say that the insurance company is not fair and just. So the loss adjuster is supposed to be impartial. It doesn't stand on either side. But recently there have been cases where over 100 cases where under investigation where loss adjusters are involved. Of course, I understand there hasn't been much regulation elsewhere, but I don't believe there isn't any.
And I think perhaps you can ask the international loss adjuster companies to come up with something like a quality trademark. Now, in fact, anyone can open and operate a loss adjusting firm in Hong Kong. Yes, that's ridiculous, but that's the case. So I think this issue really has to be addressed. Now, I don't know why you've used the term lei pui si for loss adjusters in the Chinese version 2173. I think you should try to find the best term. And then I've got a question in relation to para 8.4. A person may discharge clerical administrative duties on behalf of an authorized insurer or a licensed insurance intermediary. But please don't forget that there are employees of insurance companies who meet the clients, who make cold calls, and they are not responsible for discharging clerical or administrative duties. In fact, I have lots of questions, but I think I'll ask these two questions first. Yes, these are points of detail, but then these are matters of concern to the industry. Yes, Chairman, thank you. Now we have to put down the name of the activity in the law. So we'll say that these are people who assess claims. So we think it's better or more appropriate to describe the activity rather than to use a certain term for that activity. Now concerning the making of claims, then there may not be a need for an intermediary license. But then if there is fraud, and that would amount to a criminal offense. And then there's another question. Those who do cold calling in insurance companies. In fact, these are sales or marketing activities, and these are regulated activities. and they need to obtain licenses. But at the moment, if they are employees of insurance companies, they do not need to be licensed, because they're not agents. They are merely employees of insurance companies. But it seems that the law is saying that employees of insurance companies also need to be licensed. We don't look at his status. We look at whether he carries out the regulated activity. If an employee makes calls for after-sale activities, then there is no need for a license. But then this is important, Chairman. There are many employees in insurance companies. They are not agents. Agents are self-employed persons. But then there are many employees of insurance companies who make cold calls. And is it that the company can obtain a license on their behalf? But then at the moment they are employees, and if they become agents, they become self-employed, their status is changed, they will not be covered by employees insurance. Yes, Chairman. I think Mr. Chan is referring to telemarketing stuff, not merely telemarketing stuff. If all sales activities and stuff have to be registered, then that would be really a major exercise. Now, in the UK, the regulatory body issues guidelines as to which types of employees need to be licensed and which types need not be licensed. So the IIA can issue guidelines later. But then I think we have to bear in mind the objective. The objective is to protect the consumers. Now, if an insurance company employs a group of staff members to give advice, to induce people to take out insurance, and if these people do not have the professional knowledge and expertise, then this is a regulatory problem. And also, Chairman, now we want to have a code for intermediaries because we need to protect consumers. And if there are employees who are not subject to the code and who can carry out regulated activities, then that would amount to a very big loophole. And so that's why we have regulated activities. We don't mind whether you are a bank employee, a bank staff member, or a broker, or an agent, or an employee of an insurance company. So long as you are involved in a regulated activity, you have to be bound by the code and the regime. Or else there will be people who can carry out a regulated activity in an unregulated manner. All right, I think we need to move on. I do agree that we shouldn't look at the title of the person concerned. You may be a cleaner, but then if you sell insurance policies, then you are carrying out a regulated activity and you have to be regulated. Mr. Sin Chung Kai. Now, there can be a holding company and then subsidiaries. It is said that there will have to be a separate or independent account. And what if the money is deposited with the holding company? Is that allowed? In fact, at the moment, for a broker's firm, there needs to be a separate account to hold the client's money. So there are very rigorous requirements. So the money can't be deposited with the parent company. So the company keeps an account in a bank, and then the money can't be used for other purposes if that's the client's money. Now, a warrant is not required if you enter commercial premises. A warrant is required when domestic premises are involved, but many agents are self-employed persons. They may not have a registered address. Then does it mean that warrants are required? We understand that intermediaries do have this worry concerning the power to enter premises and to inspect records. Then there may be abuse if domestic premises can be entered into. And that's why we have a provision concerning commercial premises, for example, the offices and so on and so forth. But then if I suspect that in fact a lot of records are stored at his home, then if we want to enter the home, we will have to get a warrant. And we, of course, need to explain to the court why we need to have the warrant, why we need to enter the home of the person. So in other words, we need to check the powers of the IIA, and at the same time, we do not want to hinder the work of the IIA. So do you carry out inspections at the moment? This power is not provided for in the law, but then we do carry out inspections, and at the moment insurance companies and intermediaries are very cooperative. We mainly visit the commercial premises, we look at the records. So I want to say that this is not provided for in the law, but we do carry out such inspections, and we hope that in the future this power of inspection can be clearly spelled out in the law. And concerning whether we can enter the homes, then at the moment, even if there is suspected fraud, we still have to apply for a warrant from the court. But then there are buildings which are mixed uses, commercial and residential. But I think for a CR building, the commercial portion and the residential portion are separated. It doesn't mean that a unit can be used for either residential or commercial use. But in some buildings in Mongkok, you see this unit being used for commercial use and the unit next door being used for residential purpose. We're not too worried, Chairman. If we have reasonable cause to believe that certain information is important and we need to get a warrant, we'll try to do that.
Next, Chen Kim-po. Now, that was a very fundamental change. Now, whether it's a company employee or intermediary, I agree that they should comply with the same requirement. But if you look at the law, it's stipulated that the under licensing intermediary licensing regime, apart from a licensed intermediary, one cannot do this and that. But a company employee is not an intermediary. You are changing him into an intermediary. Many people are not licensed who are engaging in that work in insurance companies. Now, if it's an intermediary system for intermediaries, but a system regarding management of insurance companies, then you have to make that clear, because many people don't know that. We have to sort this out. I have to talk to the trade, because this is a very fundamental change. Now, understand you want these people to abide by the same code, whether they are employees or intermediaries. So what are we to do? Will we change these people into self-employed persons? So this is a complex issue. I will certainly pursue that matter in future. Now, further questions. Now, this document, okay, I think I will wait till the next document. Can I ask questions on document 02? Now, that has not been walked through by the administration. Let's stick to this one first. Now, Mr. Sin Chung Kai, I didn't quite understand about this issue of fundamental change. Now, how do you mean that it's so fundamental? Because when I read the document, I don't see a big problem, because the SFO also regulates such activities. Now, Chairman, the electrical policy guidelines are that if anyone engages in the electrical brief says that if a person engages in an activity, there's a contract with the insurance company, and the contract provides insurance cover, then the person who engages in that activity has to be professionally qualified and must have a certain level of integrity before he can become a licensee. So in any regulatory regime, we look at the activity. It's not that if he's an insurance company, then that makes a difference. Now, many insurance companies engage employees in telemarketing under some circumstances. There is no advice being given that would expedite or the entering into of a contract, merely concerns about health checks and so on. So that may not be the activity of an intermediary. But if he gives advice, then he has to be licensed. Now, if we exempt him just because he is an employee of intermediary, how do we safeguard the interests of the consumer? Now, there is only regulated activity, no activity of intermediary in the annex. So I can see 1, 2, 3, but I don't see what you mean by activity of intermediary. Now, in law, we merely say regulated activity. Is there a law on activity of intermediary? There isn't. Now, can I supplement? Please educate me. There is no such regulation now. If you say this system is okay or not, one has to understand about the business. All over the years, this has been differentiated this way. Either you are an agent or a broker, there is a contract, and then there is a third category, employee of insurance company. Right now, employees of insurance companies do not have to be registered, they don't have to pay a fee, and nothing horrific has occurred. Now, have you ever seen a case where there have been problems with the insurance company employees? No, but there have been problems with insurance agents. Now, I want to leave it till later, but you want to argue with me. Now, I have been an agent for many years. These are practical difficulties. Can we leave it till next time? You can discuss it right now too, okay? Mr. Chen Kim-po says that we will leave this till next time, but let the administration answer. Can I ask the administration to answer? There are 40-odd seconds left. Mr. Chen mentioned a point that I understand well. I'm also very familiar with the industry. Now, I know what you mean by employee of insurance company, those who engage in telephone work as one type. There are others who engage in customer service. There are so-called orphan contracts. Now, so there are customers who want to deal directly with the company. So some of the employees have been licensed, some have not. Some who deal with claims, maybe they fall into this category. So Mr. Chen is saying that these may not be people who engage in sales, but they handle such things. So would they fall into it? Now, our principle is if they engage in this regulated activity, then we intend to ask them to be licensed. They have to pass the exam and be licensed, and then they are regulated. Now, if you say this is a fundamental change, well, previously, if you sell the product, you're either an agent or a broker. And I know that the number is not that large. So if you are to include these people in the regulatory regime, then all the intermediaries are regulated. Now, I can discuss further in detail with Mr. Chen and with the trade. Now, I have engaged in many rounds of discussion with the trade. I haven't seen them raise a lot of made many representations on this matter. If they now feel this is very important, I can discuss with them on the extent of the seriousness. But our principle is that we hope such regulated activity will be included properly in the system, no matter what your position is. If some people are direct employees of the insurance company, they did it. They didn't have to be licensed. But if you are an intermediary or if you are a bank employee, you have to be licensed. Then I don't see why we have to be lenient with the former. So in principle, they should be included if they engage in regulated activity. But if the trade feels that there are major operational problems, then we can discuss with them on how Now, we can discuss further. I understand that there are not that many people affected because I do know the number of employees engaged in these activities in the company, so I am well aware throughout the past 4 years, this was not a major issue in our discussions with them. Now, if individual companies feel there is a problem after the meeting, I can further discuss with the insurance companies concerned what are their concerns. Now, if we and then we can see whether there's a way to resolve this. Next, Chen Kim-po. Before Mr. Chen Kim-po speaks, I'd like to remind Mr. Sin Chung Kai, your time is your time. You cannot give your time to any other member. You said you give your time to Chen Kim-po. Well, in that case, why does one have to raise your hand? Now, there's no such rule. Next, Chen Kim Paul. I really do have to speak on behalf of the insurance sector. Ms. Choi is respected by me. She spends a lot of time resolving problems for the trade. But I'd like you to understand now, previously it's a self-regulatory regime. The law is not that clear. There's a code. There are only 3 organizations. One is the insurance intermediary, insurance agent registration board, and there's no one dealing with the insurance companies. They are excluded. So our understanding was that you would follow the existing system. Now, it's only 10 minutes ago that I found out that that's what you are thinking. It's a major problem. There are many people like that. The regulated activity is very broad. Now, when you issue a receipt, that's a regulated activity. Now, I was fortunate in being very familiar with the process. I've offered many views to the government. Now, when you get a leaflet from the bank, one cannot just read the leaflet to the client. Now, so don't think that we have not spoken out. We have just found this out, so we will go back to talk to the trade about this important issue. Now, these are employees. You don't have to ask them to register. Now, I can't say I can accept this on behalf of the trade. Now, if they merely type out an invoice, then we say we exempt them. Now, but there are many other things that is difficult to foresee. You should stipulate and make this clear to the trade. If you are speaking in general terms, the trade will be very concerned. Now, there are many people who engage purely in sales. Now, there are people who form companies to engage in agent work. Now, if you say this is a new trend, that is different. Now, I have to differentiate. If they merely type out an invoice and perform clerical or administrative work, then in the new bracket 121, bracket 2, that's exempted. Now, but if you say that some people engage in sales because it's costly, then I engage in people to do the selling, then that's regulated activity. I haven't moved the goalpost. We want to regulate the regulated activity, so we have to try to include that in order to safeguard the interests of the consumer. Now, if you think you are concerned about people being caught when doing administrative work, well, they are already exempted. Now, if you want us to put in writing who are exempted, we can do that, but we have to differentiate by what they are doing. The administration should properly communicate with the trade on this regard. Maybe each side has different definitions. Now, this is a new situation as raised by Mr. Chen Kim Paul. Originally, we were going to move to Sin Chung Kai, but our time is up. We have to surrender the venue. I have to attend another meeting at 4:32. So the meeting will end now. The next meeting will be 12th of November, Tuesday, 2:30 p.m. and 14th of November, also 2:30 p.m., we will discuss the item 3.